Muy bien, bienvenidos nuevamente. Vamos a dar comienzo al panel sobre desafíos legales para invertir en minería en Latinoamérica. Nos va a acompañar como moderador Matías Argarate. Matías es abogado con extensa trayectoria en la industria minera. Es actualmente director de Asuntos Legales de Patagonia Doyle. Matías, te invito a prender la cámara y micrófono. El panel va a ser parcialmente conducido tanto en español como en inglés. Nos van a acompañar Shawn Doyle y Rachel Speight. Y luego se sumará Denis Silva para hablar sobre algunos aspectos en particular. Mati, la mejor de las suertes con el panel, seguro que va a salir muy bien, es un tema súper interesante. Shawn and Rachel, good luck. Thank you very much for joining us in this event. I'm sure that you will do a terrific job, so I look forward to listening all interesting things that you have to say. Thank you very much.
Bueno, muchas gracias, Leo. Quiero agradecerles a todos su participación, a todos los asistentes en este segundo Congreso Internacional de Minería que organiza IADEM, y en particular en este panel sobre desafíos legales para invertir en minería en Latinoamérica. Bueno, ya Leo me ha presentado, gracias nuevamente, y tengo el gusto de ser el moderador para este panel, en el que se estarán abordando aspectos desafiantes según la mirada de los asesores legales externos que van a estar participando del mismo, respecto a los inversores mineros y a los abogados in-house a la hora de invertir y desarrollar actividades mineras en Latinoamérica. Lógicamente estos desafíos legales son los que en definitiva tienen que ser abordados para que al final del día y en el largo plazo tengamos condiciones necesarias de previsibilidad, reglas claras de juego, en fin, la seguridad jurídica que tanto pregonamos para potenciar estos incentivos, para que venga más inversión a Latinoamérica, para asegurar un ambiente propicio de minería en la región. We are now going to switch into English, as the majority of the members of this panel don't speak Spanish. I would like to remind you that you can use the question and answer device that you have at the bottom of your Zoom screen to ask any questions that you would like to be addressed by the panelists. These questions will be answered at the end of the discussion. Now I'm going to introduce you to the panelists of the webinar, and then each of them will introduce themselves to the audience to share their mining experience in Latin America, and we'll discuss the main challenges they use to deal with while providing legal advice to their mining clients that invest or are planning, assessing the possibility of investing in Latin America. We'll start with Rachel. Rachel Speight is a partner in the finance practice of Mayer Brown's London office, where she has worked for over 20 years. Mayer Brown is an international law firm with offices in all the major financial centers across the globe. Rachel represents banks and sponsors in international structured and project financings. She particularly focuses on the mining sector and has advised on mining projects in Latin America, particularly in Panama, Mexico, and Chile, but also across Africa, Europe, and parts of Asia, so she can bring an international dimension to the panel. Rachel is also an active member of Women in Mining UK, a not-for-profit organization which aims to promote the employment, retention and progress of women in the mining industry, which is affiliated with Women in Mining Argentina. The other member of the panel is Denis Silva. Denis is a partner at DLA Piper Canada and focuses his practice on corporate finance and mergers and acquisitions, and has extensive experience advising public and private clients in the mining sector on a full range of business law matters. Denis' experience in Argentina has been primarily focused on advising royalty companies on acquiring existing royalties on producing and development stage properties. Denis also advises issuers with mining projects in Ecuador, Colombia, and Mexico, as well as other jurisdictions. And finally, Shawn, he is originally a US lawyer. He received his JD from Harvard and worked for a number of years at Cleary Gottlieb with a special focus on Latin America before moving to Canada and requalifying as a Canadian lawyer. Today, he heads up the Latin America practice at McCarthy Tetrault, which is a leading firm in providing services to mining companies from around the world. Shawn also spent many years in Chile during his youth and subsequently worked in Chile during different periods, including recently in the mining industry. He's a former director of Consejo Minero, the main mining industry association in Chile. Now he divides his time between Vancouver and Santiago, and he travels frequently throughout the region. He joined us from Miami today because he has lived for many years in Chile. He speaks perfectly Spanish. Shawn, I would invite you to introduce yourself to our audience, which is mostly in Argentina, in Spanish, please, if you agree.
Yes. Bueno, soy Shawn, como dijo Matías. Hice mis estudios en los Estados Unidos y empecé mi carrera en Cleary, donde me integré a su Latin America Practice. Y ahí en Cleary, el grupo al cual pertenecí hacía operaciones exclusivamente en Latinoamérica, no solo los que tenían que ver con la minería, sino muchas otras también. Más adelante me mudé a Canadá y cumplí los requisitos necesarios para llegar a ser un abogado canadiense. Y cuando empecé a trabajar en McCarthy Tetrault en Vancouver, me di cuenta que uno de los ejes más importantes entre Canadá y Latinoamérica era, por supuesto, la minería. Entonces me empecé a enfocar en esta industria. Después de un tiempo salí del estudio y ejercí por un tiempo como fiscal, es decir, como General Counsel de una minera grande, y luego por un tiempo gerente de esa misma minera en Chile. Fui su country manager. Entonces me ha tocado vivir los desafíos de la minería en Latinoamérica desde la perspectiva no solo de un abogado, sino también como el gerente del proponente de un proyecto minero y el gerente también de una faena en fase de operación. Ahora he vuelto a ejercer como abogado, otra vez en el mismo estudio, pero siempre con un enfoque en la minería en Latinoamérica. Y sigo pasando una parte sustancial de mi tiempo en Latinoamérica, sobre todo en Chile, donde mantengo la residencia. Ahora, yo diría que cuando se trata del marco legal que existe para la minería o para hacer negocios en Latinoamérica, lo primero que hay que reconocer es que es una región enorme con muchas diferencias y ese marco legal, por supuesto, varía de país en país. Y uno tan solo tiene que ver los rankings del Fraser Institute, que ordena las jurisdicciones del mundo en cuanto al reglamento que tienen para la minería, dando mejores rankings a los países que tienen leyes y regulaciones claras y eficientes que facilitan la minería responsable. Y si uno ve esos rankings, uno ve que jurisdicciones como la provincia de Salta o todo el país de Chile son mejores que jurisdicciones mineras como la Columbia Británica, mi provincia, y Ontario, en Canadá, o Colorado, en Estados Unidos. Uno ve que Santa Cruz es también mejor que la Columbia Británica, mi provincia, y que Perú está más o menos al mismo nivel. Ahora es cierto que hay otros lugares como Mendoza o Bolivia que están en los ultimísimos lugares del ranking, pero lo que quiero decir es que hay muchísima variabilidad en este tema y también que no se puede decir que el sistema jurídico no esté funcionando en Latinoamérica, nada por el estilo, en absoluto. En muchos lugares está funcionando muy bien. Sin embargo, hay algunos aspectos del sistema legal que son comunes en este continente y que pueden causar sorpresa para las mineras extranjeras si no están bien preparadas. Y para mí uno es el formalismo. En Latinoamérica todo viene en triplicado, con firmas y timbres, y tiene que pasar por notarías, y se tienen que pagar impuestos de timbre y cosas así. Y para las mineras canadienses o estadounidenses o australianas, el nivel de formalismo que hay y cuánto tiempo se requiere para hacer un trámite, o constituir una sociedad, o conseguir un número tributario, etcétera, etcétera, puede ser sorprendente a veces. La segunda cosa que por lo general puede causar sorpresa entre los clientes mineros es el bajo nivel de certeza sobre muchos temas legales en muchos países de Latinoamérica. Algunos países, como Perú y como Chile, tienen industrias mineras muy importantes y tienen sistemas regulatorios también muy desarrollados que dan mucha seguridad sobre los requisitos, los plazos, los pasos que hay que tomar, las posibles respuestas del gobierno. Pero en muchos otros países la regulación es mucho menos clara, su funcionamiento se ha comprobado mucho menos y hay más preguntas que en Canadá, por ejemplo, sobre lo que es y no es legal, sobre cómo hay que proceder, sobre cuál es el espectro de posibles reacciones que uno podría esperar de un regulador dado, etc. Entonces esa es la segunda cosa. Y luego otra sorpresa es la que le espera al abogado estadounidense o canadiense o inglés, que viniendo del mundo del common law con su infinita flexibilidad, da por sentado y sin fundamento alguno que todo lo que se hace, por ejemplo, para estructurar un joint venture en Norteamérica, en Australia, en Sudáfrica, o donde sea, se puede hacer del mismo modo en Latinoamérica y no siempre es así. Todos hemos hecho este error alguna vez y el error puede ser muy caro. Y por eso es tan importante que nosotros, los abogados extranjeros, cuando hacemos operaciones en Latinoamérica, nos dejemos guiar por los abogados locales que saben mejor que nosotros y nos pueden entregar un servicio enormemente valioso si les dejamos hacerlo. Bueno, esos son mis comentarios generales, Matías, y quedaré a la espera de la discusión en la que nos vas a guiar en inglés. Gracias.
Muchas gracias, Shawn. Muy interesante tu introducción. And now I will ask Rachel to go ahead and introduce herself.
Thank you, Matías. Hello, everyone. Thank you very much for inviting me onto this panel. I hope we have an interesting discussion. My name is Rachel Speight. I am a partner in Mayer Brown, as Matías said, which is an international law firm. I'm based in London, where the temperature is just above freezing, but I know that Shawn's come from Vancouver, where it's a lot colder, so I can't complain. As Matías mentioned, I've been involved in a number of projects in Latin America across the whole region, from Panama, Chile, Mexico, even looked at some lithium projects in Argentina as well. And a lot of my practice also involves Europe and Africa. So I hope I can bring a little bit of a comparison between what goes on in Latin America and perhaps what the comparable regime is in Africa, which is, of course, a major mining jurisdiction as well. So the title of this panel, and I know that a number of you have spent some time at this conference listening to various other people, but the title of our panel is Legal Challenges to Investment in the Mining Industry, and we were asked to say a few words about our thoughts on that. Unfortunately, my Spanish isn't good enough, so I don't know quite what Shawn covered, so maybe I might be repeating what he said, so you bear with me. But one of the things I thought I might flip the title a little bit in our discussion today. Legal challenges sounds quite negative, and I wondered if we might be a little bit more positive and think about some of the opportunities and some of the legal opportunities there are for us involved in this sector, and see if we can put a positive spin on it. I know many on this webinar are lawyers and heavily involved in the mining industry, and I think this is a really exciting moment for us. I think in the recent years, which has been accelerated even more so over the last 18 months or so, is that the world is now looking to the mining industry to promote itself in the environmental situation, to capture the green credentials which the mining industry has. You know, we think about copper and its importance in the renewables sector. And I think that we can harness some of the legal regimes that we are all involved with to make sure that the mining industry is at the forefront of that change, driving that green agenda with the advent of electric vehicles. And I'm conscious of talking to some experts here, but you know, the importance of lithium, you know, which is obviously crucial in Argentina, but across the globe, and cobalt and other minerals like that. And how we can promote that development of the mining industry in a positive spin, and what can we do as lawyers and the legal regimes to ensure that we are maximizing the potential of the sector, not just in the battery sector, but we can also think of things like fertilizers, potash, phosphate, and the importance that that is going to have in the years ahead. So I think it's very much an exciting time for the industry, an exciting time for lawyers in that industry, to see what we can do to encourage investment and harness those challenges, and see what we can do to promote them and make it an easier environment for investment to come in for the next, you know, year, 2 years, 5 years, 50 years, 100 years. And I think some of the areas, I talked a bit about the green agenda and the importance of battery metals, but there's also the energy transition that is going on, and how we can put in place legal regulations that are going to encourage that transition from fossil fuel in a mining context to people using renewable energy to power these mines, and what is the legal regime around that can encourage that to happen. You know, in a similar vein, mining projects need to be investing with their stakeholders, and what is the legal challenges or opportunities to promote that engagement. How can we position ourselves better as an industry to encourage the public perception of what the industry is doing, away from a nasty, dirty industry into something that is going to be at the forefront of this green agenda, engaging with local communities, ensuring that the tragedies that sometimes happen with environmental spills or dam collapses, ensuring that we have a strong regulatory regime that will limit the output of those. And how can we harness innovation in the mining sector? What can we do to promote the digitalization of mining companies, mining projects? That has to be the way ahead to move away from what has historically been, you know, perceived as a more dirty industry. I think we can all harness those opportunities see it as a positive way forward. So I'm conscious that there are legal challenges. There are many legal challenges in Argentina, I know. Many of you will be more familiar with those than I am sitting here in London. And some of those challenges are not unique to Latin America. Definitely you see those sort of challenges around complex legal regimes and issues with corruption and compliance regimes, and that happens across the globe. And so maybe we can take lessons from what's going on in other jurisdictions and bring them to bear in Latin America. So that was just a few introductory words about some of the opportunities for the legal sector in the mining industry, what we can do to be at the forefront of the change that's now happening, making the mining industry relevant for the years ahead, as it most definitely is, and what we can do with the legal regimes to ensure that nothing there is going to detract from the investment that needs to happen in the industry. So I'll hand back to Matías. I'm not sure if we've got our other speaker on just yet.
Okay, thank you very much, Rachel. No, I think we are just, sorry, Shawn and you. You both have done a good summary of the main challenges, and as I totally agree with you. We should try to turn these challenges into legal opportunities, for sure. I would like now to try to specifically address some of these main legal challenges or opportunities in mining Latin America. To that end, we should start with some questions that have been prepared to get your views on these topics that you have, as I said, identified as the most challenging ones. So if you agree, let's start with some questions. Good. Okay, good. First one goes for you both, and it has to do with the legal regulations and the impact on the ability of the companies to obtain funding to conduct businesses. Do you consider these legal regulations as fundamental, or does the economic situation of the host country has more influence in the ability to raise funds to develop a project? Rachel, if you want to go first, please.
Sure, thank you. I think it's a really interesting question, and definitely you need strong institutions and a strong regulatory framework to attract investment. It has to be robust. But I do think when investors are thinking about projects to put their money into, they're also perhaps have a more keen eye on what is the political situation. Is it stable? What is the economic situation? Again, is it stable? I think investors are conservative with a small c. They really want to know that there is going to be stability within a region and within a project. And that's, I think, very important when they're looking at where to put their money. Mining projects, I think, are particularly susceptible to this because they're so long-term in their investment and their outlook. So when an investor is looking to invest in a project, they need to look at what's the horizon. How many years is this project going to take? And I'm sure people on this call will know there's no fast mining project. There's no quick gain. I think in a mining project, it takes years, it takes decades. People who are looking at exploration licenses now, won't be in production for 10, 15, 20 years. So it is a very long-term business. So investors have to look at the track record and history of a country, of a region, and then anticipate what will the next 5, 10 years look like in terms of my investment. So, definitely countries and regions need strong regulatory framework. They need strong institutions to support that. But you can have the best legal regime in the world and the best institutions to maintain it. But if your political stability and political will in terms of investment in the mining industry isn't there, and if the economy is not there, it's difficult to see that investors will be attracted to the sector. You know, that the Latin America is a fantastic market for mining, of course, and nobody will ignore it, but there are other opportunities around the globe to invest money in. And so as an industry, I think we need to make it as attractive as possible, but there are those big macroeconomic factors that I think are also important. I don't know, Shawn, do you agree with that, or perhaps there are some other factors?
Yeah, by and large, I do. I mean, yeah, I think Matías' question went to whether the host country's economic situation is more important. And I would say it's not. I think the economic situation in the host country is probably not a really salient concern. It may be a third or fourth order concern. I think mines get built or bought based on predictions more about the global economy or maybe the Chinese economy, the level of expected infrastructure spending, the expected rollout of new technologies, energy technologies, things you were talking about. And therefore, at the end of the day, the global demand for metals, supply of metals, etc. But unlike those local economic conditions, which I don't think are that important, I think local politics, as you say, and local regulations do have an impact. You do see lenders less willing to lend to projects in jurisdictions that are riskier or seen as riskier, or more uncertain from a regulatory and social standpoint. And companies themselves, all else being equal, would sooner not invest in those jurisdictions. They do have some choices. I mean, the choices aren't infinite. This is the mining business. You sort of have to go where the deposits are. But there are deposits in other parts of the world, and we see recently more exploration spending moving to places like Canada and West Africa and out of Latin America due to political developments in some of the key countries. I think there's some level of regulatory friction that is below the radar of investors, things that they're just not going to notice and probably are not going to have an impact. But above some certain materiality threshold, regulations do have an impact. The general investment climate, either pro or anti-mining, the tax regime, the security of mineral tenure, the level of confidence that things will stay the way they are. I think that last point, the confidence that things will stay the way they are is sometimes an underappreciated one. I think more so maybe sometimes than having good laws, it's important to have a history of stability and not have approaches to mining that change every time the government changes. When you look at a country like Chile, which I know well, which has a very long record of steady, reasonable regulation, you can really build a brand around that. And once one has a brand, I think consciously or unconsciously, even quite sophisticated investors, they look at the brand first and the details later. If one does not have a brand, however, the details are going to get a lot more scrutiny. I think one other thing that's important, Rachel, is whether the country has a track record of seeing significant mines get built. And for example, it has become quite difficult to do business in Mexico. But for several years, mining investments have kept flowing into Mexico. And I think the situation could look different if companies had not succeeded in building a lot of major mines like Peñasquito in Mexico. And major mines like Antamina do the same for Peru. But yeah, on the whole, I think these things matter. Regulations matter. One of the best illustrations that regulations matter comes from those maps that one sometimes sees of the major mines running down the spine of the Andes, and particularly, and unfortunately for our audience, the stark disparity between the number of mines on the Chilean side and the relative paucity of mines on the Argentinian side, despite similar mineral endowments. And I think those maps really say everything about the regulatory brands of the respective countries over the past few decades, having said that, it is clear that in the past decade or so, some Argentine provinces have really steamed ahead of the rest of the country in terms of developing their own provincial brands, and some of them have surpassed Chile. So I think if they can stay stable and keep those brands, then that map is really going to change, and you're going to start to see a lot more successful mines on the Argentines. Anyway,
I was just going to add, Shawn, that, just on that development, you're of course right that places like Chile and Peru have such a history of mining that the brand, that's a good word, the brand is really strong. But there's been some interesting developments. For example, Ecuador seems to be an interesting jurisdiction that people might not have wanted to invest in. And I think you're so right.
I agree. Go ahead, sorry.
No, I think you're so right that you just need a couple of big projects to be successful, which I think is hopefully the case in Ecuador, that there's been terrific investment in the Lundin project, that might be the start of something really good.
Ecuador is an up and comer for sure. Their brand is getting better and better. Yeah.
Okay, good.
Yes.
Thank you both. Talking about the stability and the long-term view that any investor would like to have when they decide making an investment, and the horizon that was mentioned by Rachel, and the regulations and the impact of these regulations also were addressed by Shawn. I would like to ask Shawn, how do you see, if you think that the foreign exchange controls affect the possibility of doing business?
Well, we couldn't do a Argentine panel discussion without talking about foreign exchange controls then.
Yeah, sorry, I think basically talking about inflows, outflows, and repayment of payment of dividends, and all of that.
I think it really depends on how draconian they are, the availability of exceptions, the level of pressure on the local currency, and therefore the difference between the official rate and the market rate. Sometimes exchange controls are something that you just need to structure for and understand, and as long as you do that, they don't necessarily prevent investments. Although, look, no country garners any investor confidence from the imposition of exchange controls, and they are not something that stable countries, stable economies have. But, and I do think that as they become harsher, and I understand that Argentina has recently been tightening its controls and attacking some of the structures that had been used by companies to manage their funds flow requirements in the presence of controls. And if that's the case, they could really begin to bite and to affect investment. Although I understand that in Argentina, the Argentine lawyers, even now, continue to find ways around them, ways to structure around them. But things can change or get worse. And the sense with some countries is that really unpredictable changes could occur. And for foreign mining companies in these circumstances, the question will be whether or not there is anything available, either in terms of anything under local statute or the possibility of entering into an investment agreement with the government to give assurance that they will be able to obtain foreign currency and repatriate profits and pay debts. I also think that as Rachel said, mining is a long-term business, and some companies, maybe more intrepid ones, which lately may include, for example, some of the Chinese companies, may be willing to take more risks on these questions, may be willing to look past existing exchange controls and have their eye on a time when either they may have expired, or it's simply not known what the future regulation may be. What do you think, Rachel?
No, I think that's right. I think that the bringing in the Chinese example is pretty interesting because they have a strong appetite that's been shown around the world for risk in a way that perhaps some other jurisdictions don't have that appetite. So I think they'd be taking a long-term investment decision that they think that exchange controls and those sort of barriers to entry are not going to restrict them from recovering their investment.
Yeah.
Okay, good. Thank you both. The next question has to do with the legal protection of foreign investments. We'd like to know your views on what you think about the legal structure to protect foreign investments in Latin American countries. And if you think that bilateral treaties to protect these foreign investments may be the best approach, or if you have any experience with other instruments which may be more effective. Maybe Shawn, if you want to go first.
Well, sure, Matías. I would say that most of the modern bilateral treaties provide only limited protection, or rather what I should say is that they provide only the most important protection for the most egregious cases. That is, for cases where the host government is specifically seeking to discriminate against foreign investors, nationalizing foreign-owned assets, or the like. So they're relevant in the cases, some of the treaties for these types of things, and to guaranteeing the ability to transfer profits out of the country. They're important. They play an important role, and I wouldn't minimize their importance. But the treaties specifically seek to not interfere with the country's general right to regulate in the public interest, and that regulation can include things like increasing taxes or royalties, even quite markedly, or other new regulatory requirements that effectively prevent a company from developing a project or realizing a profit on an investment. So I think that where there's a sense of political risk or instability, which unfortunately is probably on the upswing in most parts of the continent, project proponents will also have some interest in, where possible, and in countries where they're available as an option, negotiating a specific investment agreement with the host state, especially for larger projects, which can deal with some of the specifics of the project, including hopefully tax stabilization where it's permitted by the local law, and deal with issues like security of tenure and some project and permitting related risks. And then another option to be examined is political risk insurance. This kind of insurance protects against some of the same risks that are covered by treaties, but it can also go further. It can include customized breach of contract coverage, which can be extended to the contractual obligations of the state-owned bodies or enterprises. Breach of contract coverage can include the inability of an investor to obtain an award due to the government's interference with the dispute resolution mechanism under a treaty or an investment agreement, or where the investor has obtained an award, but the investor has not been able to receive payment under the award. And insurance can assist projects in accessing funding with improved financial terms. So people can also look to the Multilateral Investment Guarantee Agency, which can provide political risk insurance in resource projects in some countries, if the host economy is part of the relevant convention. There are national agencies in several countries that also provide some insurance. So I think you have a variety of tools in the toolbox, and the point is, especially in riskier cases, investors will often not want to rest only on the existence of a bilateral treaty, and they'll want to sort of take a belt and suspenders approach and see all of the tools that they might use. What do you think, Rachel?
Yeah, I think that's a good point. Certainly bilateral investment treaties are good and useful in that toolbox, but I would caution anyone against carrying out an investment based solely on getting redress via a bilateral investment treaty, it really has to be your last resort. It is it is an onerous and time-consuming and expensive, and takes an awfully long time to try and recover any investment via a bilateral investment treaty. If anyone, if that was their first port of call for redress, then I think that would be a mistake. And actually, Shawn, you gave some great examples. I was sort of racking my brains to think, well, what do you do other than that? But you came up with some great examples about getting some insurance and getting others involved. The other thing I was thinking about is, you think, who are your shareholders? The IFC, the World Bank, quite often take an equity position in a number of mining projects. With them as one of your shareholders, you might think that a state might take a different stance towards a particular project, and a different, they might not, but that can be a good protection. If you were able to get funding from one of the international export credit agencies, if US Exim was financing your project, you might, your investment might be more secure than without it. So I think, that's maybe look at who is your shareholder base. Can you attract some institutional investors who would be pretty powerful on your shareholder roster? Can you attract perhaps some funders who equally could support you as that? But I think as international investment has increased,
or a local partner, right?
Yeah.
A local partner could often help to mitigate risk in a very similar manner. But go ahead.
No, that's a good point. But pick your local partner well, because someone with influence and with a track record will certainly help you navigate some of those issues that could otherwise you could fall foul of with some of these claims. So I think there's obviously been an increase in investment in the region, and with that has come an increase in the number of claims under some of these bilateral investment treaties. And actually, even in this region, a number of them have been pretty successful, in contrast perhaps to some other geographies, some other mining geographies. But I don't think that should encourage anyone to think of international investment treaties as a quick and easy fix to these problems. Actually, Shawn, that's a good point about a local investor. It goes back to the point I made at the beginning. If you have local engagement with the community, if you have the community on your side, it may dissuade any expropriation or other draconian action that could be taken against you. If the community is supportive, if the region is supportive, if your project is a success and is benefiting the region in which it's located, then those are all powerful weapons to think that there wouldn't be action taken against you and your project.
Yes, I agree.
Yeah, thanks, Paul. Going to change the subject now. I would like to know your views on the price of a mining project, the price of an asset that may have a great potential from the mineralization standpoint, and how do you think, do you consider that the legal framework of a country, of a region, may have an impact on the price or the value or the view or the attractiveness that the investor may see on this asset?
I guess it's all driven a bit by supply and demand, isn't it? If there are a number of interested buyers in a project, then the price will go up and you'll be successful in what you're selling it for. But if the legal regime is such that it doesn't attract that wide range of buyers, then the price will not be quite so attractive. So again, we mentioned Chinese investors who may be less concerned about what the legal regime is and its impact on the pricing. But if you're looking to sell an asset, you want to generate as much interest as possible. So you want to have as many buyers as you can possibly get. So if you can have that robust regulatory system and a robust legal framework around it, that's only going to increase the price and increase, but because it's increasing the pool of investors who would consider buying it.
Good. Shawn, any views on that?
I think if there's something in the regulation that has real effects on the ability to develop an asset, or on the security of tenure, or on the ability to extract profits, then it should impact the price of the asset, right? If markets are efficient, right? If you, all else being equal, if you have, you know, two deposits which are similar deposits, and one is located in a place that's stable with you know, clear regulatory regime that provides a pathway to develop the project, and the other is located in a much less stable place with much less certainty about the pathway to develop the project, then clearly one of those projects is going to be worth more than the other if markets are efficient, and I think they're efficient enough. But look, it's really more of a question for bankers than lawyers. We don't usually hear about this type of stuff, but anecdotally we do. You know, I've heard it said that a stream, for example, in one jurisdiction which is perceived to be a difficult jurisdiction, is worth less than a stream on a mine in a different jurisdiction that has a better reputation. So a reputation for regulatory certainty and judicial independence. So it has an impact. And we also hear it in the course of our work about how country risk can present challenges for the banks, for the financial institutions. And each bank will have strict country and transaction limits in place with respect to a particular jurisdiction, and generally jurisdictions that are perceived to present higher political risks or risks to the rule of law, things like this, are allocated lower country and transaction limits. Banks will not lend as much money into those countries or to projects in those countries. So a particular financial institution may have insufficient capacity to lend into a particular jurisdiction at a given point in time, no matter how well a project is structured or how bankable it may otherwise be. But I think it is not simply a matter of having a good regulatory framework so much as demonstrating stability. The risk is change in law. A mediocre regime can be structured around, but one of the most publicized and significant risks for any mining project is that changes to the laws governing the mining company's operations in the host country after the mining company has already invested substantial amounts, billions, in a project, will materially impair the project. And so countries, I think, have to look to providing stability, and a number of countries in Latin America seem to have this cyclical approach to mining, where a government of one stripe will come in and they'll say, look at us, we're now open for business, we now have attractive laws. And then, you know, the cycle turns and there's a different government of a different stripe, and there's a push to make the miners pay and go after the miners, and that impedes a country from developing that kind of brand that I'm talking about, which is really what you need to attract a lot of investment over the long term, I think.
Yeah, and some of that, Shawn, what you're saying there, it isn't a unique issue to Latin America, of course. You know, there are jurisdictions I can think of in Africa. In Tanzania did it recently. The new government comes in, increases thinks that the mining regime, the mining sector is an easy target for money, and changes the laws, and what happens? All the money leaves the country and leaves the sector, and then it takes years to rebuild it and rebuild the trust. The conservative bankers who previously might have looked at the country no longer will.
I think it takes years to build up, and once you've built up the brand, there's a certain stickiness to it. It's not going. I see what's happening in Chile right now. They have the brand. but everything that's happened in Chile over the last 2 years has been dreadful, and all the headlines have been dreadful. And so the brand has been shaken a little bit, but the brand is so well established that even in the run-up to this most recent election, which was a real nail-biter, with prospects of massive tax increases on the horizon, even in the run-up to that, we saw some fairly major investments in Chile of a order of magnitude that we never see in some other countries in Latin America. And that's the brand doing the work for them. Now, that brand is not going to adhere forever. It is slowly being damaged, and eventually, if the country allows it to happen, the brand will disappear. But once you've built it up, it does have some staying power, I think. Matías.
Okay, thanks. The next question is for Rachel and has to do with the mining transactions and the assignment of rights that they are usually involved in these mining deals. As we know, the process for the registration of the assignment of rights, let's say real estate or royalties, among others, usually takes long in Latin American countries. How does this situation influence the client's investment decision, in your view, Rachel?
It goes to some of the themes we've been talking about. Anything that slows down the process or is a barrier to investment is going to be a negative impact, without a doubt. I'm wary of my audience here, but anything that can be done to speed up some of those institutions in terms of registration, in my mind, that's an administrative process. It seems to be an easy fix. There are plenty of geographies which have the system online, and it can be done pretty swiftly. So things that take months to register just seems an unnecessary administrative bureaucracy that could be dealt with pretty easily, could be made streamlined by borrowing on what people do in other geographies to make the process work better. I mean, it's difficult for me to say because I come from a common law jurisdiction where you can put in place one security agreement that covers all the assets of a company and you have one registration, whereas obviously in Latin America you have numbers of different ways of securing different classes of assets, and it's sometimes not always possible to secure mining licenses. You have to do it via different regimes. But it seems a very easy fix for us as lawyers to fix that registration process. It always surprises me how long it takes, and that the institutions that are in charge of dealing with that are not able to do it more smoothly. Maybe not able to embrace technology and smooth that process. So again, it's just another one of those barriers that prevent the smooth running of the system. That said, is that going to stop someone investing in a country? No, it's not. It's relevant for your lenders who are coming to invest in the project when they come to look to register their security on a project. If you're not raising external debt, if you just have equity finance or other means of finance, maybe that's not so relevant. And I don't think it's enough to turn someone off an investment decision. But I think it's an example of just these little things that can help speed up the process, help enhance the brand of the country and the region, the province, to make it just that step ahead of perhaps its rivals. And I think those little things, like improving the administrative process to speed that up, I think will undoubtedly improve it.
Okay. Yeah, I agree with you.
I agree.
Okay. Let's go to another question, but in this case regarding with the validity of the signature of the parties, the the intervention that we usually have, mainly in Argentina, I would say, and also in many other countries in Latin America, but specifically here regarding the notary public. When executing agreements in Latin American countries, it is generally require the intervention of a notary public, or public notary, to prove that the signature is executing the agreement, certainly the one doing it. So it is a measure that lawyers usually recommend in order to avoid future problems with the identity of the parties. Do you believe that these measures bring any kind of problems when closing a transaction? And is it the same in common law countries? And how about executing agreement with electronic signatures? It is a long question, but Shawn, if you want to go ahead first, please.
Yeah, I mean, it's somewhat related to what Rachel was just talking about and what I talked about in my introduction about the level of formality that one finds in Latin America and that often surprises. You described it in your question as a measure that lawyers often recommend. That may be the case sometimes, but beyond that, I think what surprises business people and lawyers from common law countries is how often notarization is simply an absolute requirement to do any given thing, whether it be to form a company or transfer an asset or do much less than that. And often there's a need for a public deed or registration in the courts of transaction, and inevitably that flows through a notary. And this doesn't surprise me, having lived for many years in Latin America, and I know that in my personal life also, going to a notary is just a regular part of life and getting anything done. But for some people with more experience in North America or Europe, or I shouldn't say Europe, North America or the UK, like Rachel, the notary is a sort of obscure figure which one might almost never have a need for, and your lawyer can always replace your notary in North America, and usually does, but not so in South America or in Latin America. I also have experience with this from Italy. I spent 4 years working as a lawyer in Milan, and even with my long prior experience in Latin America, I was always surprised by the outsized role of il notaio in Italy. They're like the most esteemed, distinguished members of society. Their number is limited by law. It's kind of like being a judge, but with more prestige. And thousands of lawyers write a test each year to try to get a tiny number of seals as a notary, which is, really surprising when you look at the very the relative lack of prestige of notaries in Canada, for example. But it makes sense given I understand this whole position of the notary began in the Roman Empire, and so it remains strongest there. But yeah, the time that's required for notarization and public registrations is often surprising to Canadian or U.S. lawyers. And when I got asked to do this panel discussion, Matías, I talked to several colleagues just to get their thoughts on the challenges of Latin American legal systems, things that I could talk about with you. And I didn't get much, but what came up again and again from colleagues is that what jumped out at people the most, what they most remembered about the Latin American legal system, what most surprised them was the frequent need for notarization and often needing to get started on powers of attorney at a notary weeks before closing. In Canada, in mining deals, you can often just sign privately and be done, and often by electronic signature, as alluding to another part of your question. So there's electronic exchange of signatures, and that's it, and the deal is done. But the need for a public deed often introduces a different speed to deal timing, and signing before a notary also tends to set in motion things that are later difficult to undo. And so when you have various interrelated aspects of a deal or interconditionality, the mechanics around the formalities required in Latin America and which part needs to be undertaken first can be quite fraught. And I would note that aside from notarization, the authentication and legalization of documents in miners' home countries, in the US or Canada or the UK or elsewhere, it can also take an inordinate amount of time. And for us, this is partly an issue because we in Canada are not parties to that Hague Convention on Recognition of Foreign Documents via apostille, so you always have to go through a much longer process. So it does stick with people.
Sorry, what about Chile in your working experience there in connection with these required or recommendations of the use of notary publics in Chile?
Well, in Chile, it's very much as I just described it. It is required for everything. Everything through a notary. And it does add some time to deals. I like notaries. I feel comfortable working things through notaries. Sometimes the way things work in Canada, because I divide my time between Canada and Chile, I sometimes find in Canada that we're just ridiculously casual when it comes to important transactions. And the figure of the notary and the role of the notary, I do take some comfort from, in fact. But yes, as I say, for people who are not used to it, and you know, who in their prior lives before trying to do a deal in Chile or somewhere else in the region, have never had occasion to even think about a notary, or have never been to a notary in their lives, suddenly to have this notary take on this outsized role and be very important to a transaction seems strange to them.
Yeah, I echo that. I mean, surprised is a good word. I know the transactions that I've had that have involved notaries, and when you're dealing with US or UK banks and lenders or parties, it is always very surprising. The other thing I'd layer on top of that is the cost that people find surprising, that, you know, you've got another layer of cost that is wrapped up in the notary process, and that people sort of query the value that it adds. And I get the Roman history and the reasons why it's been put in place, but you know, it does add time, cost, complexity in what's probably already a complex transaction. And although Shawn, I like your idea that you think without the notary we were a bit casual, which is true. And signatures that have been going on in the last 18 months, I mean, you can do it with the click of your finger, and you don't even need to get your quill pen out to sign anymore. So maybe we should bring the notaries into the UK and have a bit more gravitas with our signing process.
Okay.
Yeah, I mean, sometimes when I have a Latin American client, I will make the signing process a little more complex, because I know that there's an expectation. I know that if I tell some Latin American clients that, you know, they can just sign a 150-page document by, as you say, pressing the button on a touch screen, they're going to think I'm an incompetent lawyer or something. So sometimes I put on a bit of theater, which involves, you know, putting initials on every single page of a document, because I know it makes everyone feel more comfortable, even though it's not strictly needed where we are. Anyway.
Okay. Good.
I think all the notaries have now just left the call, so in disgust and comments.
Yes, I'm sure. Okay, this is a question for Shawn. Maybe I should have asked it earlier, but it's a more general one. I would like to know if you consider that Latin American countries have broad similarities in their approaches to the regulation of mining, and if you think that Latin American countries are engaged in regulatory competition to attract mining investment.
Mm-hmm. Yeah, so there are two questions: whether there are similarities and whether they're competing with each other. Look, I do think there are broad similarities. but maybe all countries in the world have broad similarities. There are only so many ways that you can set up a mineral tenure regime or set up an environmental permitting regime. But of course, the devil is in the detail. And I think, as I said in my introductory comments, there are a lot of differences between countries within the region in terms of the level of development of their legal regimes and how much certainty they provide and how much they either facilitate or don't facilitate responsible mining. And when I say there are differences in the legal regimes, I'm not referring only to differing laws, but in differences in how they're implemented, the quality of the regulators, the science that they apply, the timeliness of administrative action, things like that. So I think, for example, that one cannot say that the current approach of Mexico, for example, where despite the legal channels for the granting of mineral rights, we currently have institutional hostility to mining, and the government simply refuses right now to issue new mining concessions. I don't think you can say that their approach is similar to the approach of other countries. At the moment, it very conspicuously is not. And I guess in this regard, it's important to note that not only are countries different in their approaches to mining, but they're also on different trajectories, as I see it. Rachel talked about Ecuador and what it's been doing. Recently, a colleague in Canada told me that in his opinion, Ecuador was a particularly dreadful jurisdiction. And I've heard others say that despite Ecuador's mineral endowment, they will simply not do business in Ecuador. And maybe that was the case, but Ecuador recently, under President Lasso, has clearly been improving, making some efforts to introduce a modern and certain mining regime, whereas some of the old stalwarts of the industry, like Chile and Peru, seem to be moving on a different trajectory towards regulatory regimes that will create more of a disincentive to do business, or at least mining business in those countries. So I think it's an ever dynamic playing field, and on that field, to your second question, are countries competing? Look, I think they certainly attempt to give an impression that they are doing things. Every year at PDAC in Toronto, we get the mining ministers coming from all over the region to speak about and highlight why their country is now more attractive or the most attractive for mining investment, and they'll tell you about their new laws. But I think there can be a lot of smoke and mirrors on this question, and I also think that some countries in the region, unfortunately, as I said before, they go through these real cycles between trying to attract the industry, to trying to drum them out of the country, and miners are wary of that cyclicality that exists in some places. So I think, as I said before, it's not enough to have good laws. People want to see, investors want to see evidence of long-term stability in those laws. And once you achieve that reputation for long-term stability in a mining-friendly regime, then that reputation really starts to pay dividends. And I mentioned, before the case of Chile and why, because of their brand, even in the face of the significant upheaval that Chile has faced lately, you're still seeing some large acquisitions and mine developments there. I think if some other countries had been experiencing the kinds of problems Chile has had in the last 2 years of widespread riots, the totally uncertain process to redraft its constitution, led by the left and the far left and some unknown independents, and a resurgent communist party, and proposals for draconian new tax and royalty regimes. If they had all of that, they would not be seeing other countries. If they had all that, they would not be seeing things like this recent $1.5 billion acquisition of a minority interest in Sierra Gorda. But Chile is seeing that despite all of this bad news, because it's still coasting on that long-term brand. It won't last forever, but it seems to be sticking for now. So I guess we'll see. We'll see if countries compete as well now that Chile seems to be on a different path to be toughest on mining. Chile's had this traditional role as a sort of beacon for the rest of the region, or showing the way for what the rest of the region should be doing, which is not, I know, a popular thing to say in front of a mostly Argentine audience. But I think that now there is a risk of competition maybe going the other way to see who can be the toughest on mining. Mm-hmm. And when we see extreme proposals around taxes or other regulation coming out of Chile, I worry that this maybe gives license to some other countries, mainly Peru, maybe some others, to potentially propose the same. And I think you see probably some inspiration from Chile in some of the Peru Libre platform and the program in Peru. But maybe you'll see positive competition. I think you see Argentina taking advantage, perhaps, in the lithium space of stagnation in Chile's industry, which is caused by regulatory dysfunction in Chile in relation to lithium particularly. And Argentina is more accommodating. And maybe you'll see Chile a little bit peering over its shoulder, peering over the mountains at the growth of the lithium industry in Argentina and thinking, maybe we better get our house in order and create a real system to grant lithium rights to private investors, not only the state. And you do see them making some noise about and taking some steps to do that right now. So yeah, you do see some competition. You do also see some competition that's the wrong kind of competition. And then you do also see this sort of fake competition, which every year gets put on display at PDAC.
And just picking up on your PDAC example, this week in London, it's a very small conference, but Minds and Money, which is the London tiny equivalent of PDAC. And I was there this morning, and the biggest stand by far was from the government of Saudi Arabia, which is the first time I've seen them. So watch out, Peru and Chile, because Saudi Arabia are coming after you. But which I think is interesting. That's obviously those geographies have got a different agenda, and they're looking to pivot away from oil and gas. But I think, if we think on a global scale, I think the competition is everywhere. So people do need to, the countries and jurisdictions and governments need to bear that in mind.
Yeah, no, it's true. The competition is worldwide. I wouldn't say it's everywhere. I mean, the deposits are where they are, and some countries are blessed with big mineral endowments, and others not so. And so it's not like the textile manufacturing business, perhaps, or some other businesses that you really could take anywhere. So the countries do have some ability to rest on their laurels and just say to investors, if you're interested in exploiting these deposits, these are the terms and conditions. But there are limits to that, and I think that's what we're saying.
Good. Okay, thanks. Next question goes to Rachel. I know that you have already covered or made some comments regarding the stakeholder engagement, but I would like to know if you want to add any additional one to see for you what is the importance of stakeholder engagement in the mining sector. If you want to share with us, how does the stakeholder engagement, in Latin America compare to other jurisdictions?
Yeah, I really think it's one of the most fundamentally important points for any mining company to bear in mind. What do I mean by stakeholder engagement? It's with your local community on a very tiny level. Who is the village elder in the nearest region, to a more provincial level, to a whole country level, and it's important to invest in each of those different areas to have your project be a success, because if you have one of those against you, you're going to be in trouble. And I know that in Latin America there are compulsory consultations that have to go on with local communities to ensure their buy-in, and And that's very much the case, I think, in other geographies. Actually, Shawn will probably say in Canada, I think that's a very important part of the process in the mining sector as well, to have local engagement with the communities. The projects just cannot be successful without that engagement. And I think we can see numerous examples. Peru has one where, where if you get your community against you, the project is finished. You just can't get over it. There's numerous examples closer to me here in Europe, in Armenia. The roads have been blocked, access to projects have been blocked, and it can just kill the project entirely. You get that local sentiment against you, you get NGOs against you, and it's just a downward spiral. So it's very important to get them on board. And actually, we touched on it earlier, getting a joint venture partner who's a local joint venture partner, getting the right partner can really help you with that process. It can be seen as a really positive attribute to a project. I think it can really increase your value as a project if you can show that you have genuinely partaken in that engagement, that you are genuinely embedded within the community. I think if you were thinking of selling your asset in the future years, if you have that sort of engagement with the local community, then it's a terrific asset to you. We talked earlier about, what does regulation impact on the value? Well, I think stakeholder engagement and stakeholder support can fantastically increase your value and attractiveness to international investors.
Okay, thank you. We are running out of time, but we still have 15 minutes left. So next question will be John, and as we have already covered the stability and the long-term policies that are necessary for a good horizon in terms of the investments and the view of the investors for the Latin America jurisdictions. I would like to ask John, which one is the reason, what is the reason for choosing in most Latin American transactions foreign laws applicable to the agreements instead of laws of Latin American countries?
Well, I think it's true that that's common, but I also think it's important for you to know that it doesn't just affect Latin America. In the world, two jurisdictions, New York and then England and Wales, have a certain dominance in terms of having their laws applied to international business transactions. And so it's not unusual for other Europeans, I used to practice in Italy, or Canadians or Australians or Asians or even Californians or Texans to find themselves confronting insistence on using the laws of New York or the laws of England and Wales to govern a transaction, even when, as is often the case, none of the parties are from either of those two jurisdictions. So the insistence on using foreign laws shouldn't necessarily strike Latin American lawyers as a sign of non-confidence in local laws. But I do think there probably is some of that lack of confidence, a sense that Latin American countries' laws might be less developed, less certain, less predictable, etc. And there's probably some truth to that as well, in fairness, partly because these things tend to be self-reinforcing. The more deals that are done under New York law, the more litigations exist under New York law, and the more fleshed out and predictable the law of New York becomes. And it's also driven by a desire sometimes to avoid giving a home court advantage, especially in mining, for example, in a JV with a local partner who might be seen to have great knowledge of local law and an ability to exploit it to the potential detriment of the foreign partner. Or if you have two foreign partners, they may just both sense that it would just be easier for them both to litigate or arbitrate offshore. On the other hand, sometimes there's a need to apply local law to ensure the correct transfer of property, for example, or the correct establishment and perfection of a security interest. So the avoiding of local law is definitely not absolute. Canadian courts won't take jurisdiction in matters involving in rem rights, property rights, in other countries. So in these cases, which arise often in mining, it's important to apply local law, local court jurisdiction, royalty for agreements, for example, if in the country in question a royalty right is an in rem right, and often it's not, but if it is, then you're going to need to apply local law for that reason. But in other cases where you're talking about in personam contract rights, other considerations come into play, and these include the ease of litigation in a known jurisdiction where one has a presence, a desire to not have to invest. Often it's just a desire to not have to invest the time and money in trying to determine how local law would impact a transaction. Even if, you know, local law would work fine, it does take time to confirm that. Perhaps sometimes there's even some unconscious application of the self-interest of foreign lawyers who would prefer that any eventual dispute be handled by their firm. But in Latin America, there can be some more particular reasons. In some jurisdictions in Latin America, minority shareholder rights can go well beyond what exists under common law statutes, and that can be a reason, for example, for using an offshore vehicle for a JV, for example. Our firm has seen a case where one of the majors, a client of ours, a major, was materially surprised to discover that a local partner had a whole bunch of rights that were not contemplated by the JV agreement. So for JV agreements, using foreign corporate law can also help. It can also help to avoid some of the strict formalism of Latin American corporate law in preference of that greater flexibility that you see in the common law. But yeah, sometimes as for security interests, you have no choice but to apply the law of the jurisdiction where the asset is, and so you have to educate yourself about it. And our firm has seen, for example, that the laws on security foreclosure are very debtor friendly in Mexico. So it can be very laborious to try to foreclose, and it's important to ask questions about these types of things to local counsel and respect the importance of what they do. I would add one further remark, which is that right now in countries like Chile, which is undergoing this process to rewrite its constitution, or Peru, which has a very radical government, there is probably very little appetite to apply local law to anything if it can be avoided, because it's seen, rightly or wrongly, as being entirely subject to change right now. And so that's an important consideration as well. Does that answer your question?
Yeah, totally.
I think the other thing, just to chip in on that as well, is that you quite often see transactions structured in such a way, as you were saying, Shawn, to really limit the exposure to local law, you know, interposing an international company above the structure to enable, for example, a lender to take security offshore and then never have to deal with some of the issues which might be encountered by going to the courts or an enforcement process in a Latin American jurisdiction. I mean, that's not unique to Latin America, but definitely you see people deliberately structure to try and get that offshore jurisdictions involved, and you know, some of that is just comfort that they have and a track record that they have of dealing with either New York or English law, and some of the history that those jurisdictions have in dealing with complex disputes and complex financial instruments and unraveling the whole process.
Yeah, I think you're right, and I mean, Matías's question was about the choice of law, but the other part of that, of course, what goes hand in hand with that is the jurisdiction of the courts of the local countries. Sure. I think look, I think there is fear that decisions by Latin American courts may suffer in any of a few different ways. First, they may be produced by corruption or political interference. Second, they may just be biased in other ways in favor of local companies. And one of the majors has had some disputes with the state copper producer in Chile, and those are fairly well known, but and other times they may just be unpredictable. I think that the reasonableness of this fear varies greatly from country to country. Sometimes it's unfounded, but my candid impression is that it's very reasonable and well-founded in certain Latin American countries. So, corruption is a fear, and we know that it's very real in some countries in the region. And the institutions, the judiciary is not as strong in some countries as it is in others. I understand that Brazil, like Chile, sort of offers a real judicial career track, but in many other countries, there isn't a judicial career track per se, and the judgeships are filled by non-tenured judges, which makes them dependent on their political patrons to an extent, and funding support for the courts is sometimes not high enough. Salaries are often not very good. This is not the case everywhere, and obviously some countries are doing considerably better, but it is something that companies bear in mind. And just as I noted that this doesn't, that the choice of foreign laws doesn't only impact Latin America, also the choice of foreign forums for dispute resolution doesn't only affect Latin America. One of the clients of our firm went into Alaska for a mining project, and there was a suggestion to submit to the jurisdiction of the courts of Alaska. But there was a sense that for some that Alaska was just too small a jurisdiction, and that the judiciary there was, and the bar there were just too clubby, too closed, too small. And so there was a desire to not take this perceived risk and not submit to the courts of Alaska. So you see this all over, not just in Latin America. And of course, if you're doing business with government, all of these with the local government, all of these concerns are heightened, and most companies will be looking to have arbitration in an international forum. Matías.
Yeah, okay. Thank you both. We have run out of time now. I would like to give you one last minute in order to get any final remarks from you, that any final comment that you would like to provide to our audience. In case you want, we have not get any. I think that we have covered most of the main challenges, so we have prevented the audience to make any specific question, additional one. So go ahead if you want to.
I'd probably just sum up and say back to how I introduced that there are some challenges, and Shawn and I and Matías have covered some of these. Things around the regulations, making things easier, some of the bureaucracies, corruption, things like this that do hamper the industry. But I think as lawyers, the future is bright. The Latin American region is such a terrific region for mining, with such a deep history that it just can't be ignored. And so I think the years ahead are going to be very bright as the political situations become easier, as investment opportunities become more attractive, I'm sure that the future ahead will be very bright.
Thank you.
And I agree with that, Matías. I mean, I think that the opportunities that Rachel talked about are there. I think everyone in mining today is very upbeat about the future of the industry. The global need for its products is palpable. And many jurisdictions in Latin America, as I said at the outset, have very attractive, well-functioning regulatory and legal regimes when applied to mining, some of the best in the world. So there are challenges here and there. There are things that can be improved in Latin America, just as there can be everywhere. But I think, especially with the assistance of local lawyers in Latin America to guide us through the idiosyncrasies of the respective countries, we can get things done. We can work together to get deals done for clients, and that's what we focus on every day. Thank you, Matías, and thank you, Rachel.
Yeah, thank you.
Okay, thank you both. I want to thank you all so much for your participation in the panel. And Rachel and Shawn, your presentation have been outstanding. You have shared your experience and point of view with us, most of which I'm sure, or I hope, that may have triggered great ideas and new approaches to our audience. Thank you so much, you all.
Thank you.
Thank you, Matías.
Okay, the panel has finished. Quiero agradecerles a todos los asistentes por su participación. Esperamos que hayan disfrutado de este webinar y queremos recordarles que en unos minutos va a empezar el siguiente. Ahora hay un break hasta las 12:45 del Congreso, y a esa hora dará comienzo el panel sobre financiamiento de proyectos mineros acerca de garantías y stepping rights. Nuevamente, muchas gracias a todos y será hasta la próxima.